Good day, good people. I am doing this particular video in relation to the Vexatious Proceedings Act, and I will show you what has been applied in relation to me, fraudulently so. And then this basically goes to Judge President Hlophe and Ruanne David at the Registrar of the Western Cape High Court. You need to allow me to exercise my fundamental human rights in terms of Section 34 of the Constitution, and allow me to have any dispute, including this particular dispute, that can be resolved by the application of law decided in a fair public hearing before a court, or where appropriate another independent and impartial tribunal or forum. I will take you quickly to the order that is at play, and that particular order is as follows. It was in the High Court of South Africa, Western Cape Division, Cape Town, on 14 September 2018 at Cape Town, before the Honorable Mr. Justice Davis, on case number 15141 of 2018, where the applicant is the Minister of Defense and Sylvester Vulane Mangolele is the first respondent. South African Human Rights Commission is the second respondent. South African Broadcasting Corporation is the third respondent, and Cell C Proprietary Limited is the fourth respondent. It's an application for restriction on respondents' institution of vexatious legal proceedings in terms of Section 21B and C of the Vexatious Proceedings Act 3 of 1956. It was ordered that in terms of Section 21B and C of the Vexatious Proceedings Act 3 of 1956, and for an indefinite period, no legal proceedings shall be instituted by the first respondent. The first respondent here is Sylvester Vulane Mangolele, that is myself, against any person in any court or any inferior court without the leave of this court or any judge thereof, or that inferior court, as the case may be, leave. When we go to Section 21B of the Vexatious Proceedings Act, because this thing must be in terms of that particular section, the Vexatious Proceedings Act 3 of 1956, in Section 21B of it, it says, if on application made by any person against whom legal proceedings have been instituted by any other person, or who has reason to believe that the institution of legal proceedings against him is contemplated by any other person, the court is satisfied that the said person has persistently and without any reasonable ground instituted legal proceedings in any court or in any inferior court, whether against the same person or against different persons. The court may, after hearing that person or giving him an opportunity of being heard, order that no legal proceedings shall be instituted by him against any person in any court or any inferior court without the leave of the court or any judge thereof, or that inferior court, as the case may be, and such leave shall not be granted unless the court or judge or the inferior court, as the case may be, is satisfied that the proceedings are not an abuse of the process of the court and that there is a prima facie ground for the proceedings. And section 121C, while we are there, an order granted under paragraph A or B, which is what we've been referring to, may be issued for an indefinite period, as it has been, or for such period as the court may determine. And the court may at any time, on good cause shown, rescind or vary any order so issued. So we go back to this. It means section 21B. That means in terms of section 21B, I was given an opportunity of being heard, or was heard on the 14th of September 2018. I was heard. This is according to this thing. That means on 14 September 2018 I was in Cape Town. Do you understand that particular reality? And the reality is that I was not in Cape Town at that particular time. I was in Pretoria, wherein I have met with Deputy Judge President Ledwaba after I've appeared in court at 6 a.m. in the morning before the Honorable Madam Khumalo J, and then later that day on 13 September 2018 I have appeared before the Honorable Rabbie J, who was the senior judge of the day in that day, and they both denied me leave to come to Cape Town and attend this particular hearing that was supposed to be heard by a full bench, which basically means 3 judges, and as granted by Judge President Hlophe on the 24th of August 2018. Furthermore, such leave shall not be granted unless the court or judge or the inferior court, as the case may be, is satisfied that the proceedings are not an abuse of the process of the court and that there is a prima facie ground for the proceedings and the first respondent has provided security for the applicant's cost. Such leave shall not be granted unless the court or judge or the inferior court, as the case may be, is satisfied that the first respondent has satisfied the judgment cost under case number 11025 of 18, 12095 of 18, and then 13505 of 18. The cost of this application be paid by the first respondent on the scale as between attorney and own client by order of court registrar, and that was that. I am looking here for Judge President Hlophe, and I cannot find Judge President Hlophe as it is mentioned here on this email that I have received this day an hour ago on 20 past 1 or 1:19 p.m. by Ruanne Davis, who says, "Good day, Mr. Mangolele, and by calling me Mr., you are disrespecting the President, because I am Lieutenant Commander. That is my rank, that is my title, and such a title is in terms of Section 54 of the Defence Act, in which an obligation is imposed in terms of Section 54, the 54.3a, that only the President may cancel the my permanent commission, and such permanent commission may be cancelled after due course has been followed. You cannot be calling me a Mr. after I have been telling you all this particular reality at all times. You are saying to me, Ruanne Davis, as the registrar, the chief registrar of the Western Cape High Court, that as you are aware, you are declared a vexatious litigant and will need to seek permission from the Judge President to litigate in our court. Kindly provide us with such permission so that we can set the matter down failing which the matter will not be placed on the court roll. Thank you, Ruanne David, Mrs. Chief Registrar, and then High Court, Western Cape Division, Cape Town, as is that. She was responding to a mail that I have sent later that day at noon, wherein I was saying what I have said on the previous video that I have live streamed on Facebook in this particular regard. That is basically that issue. Good people, we cannot be in a situation where now we allow criminal activity, corruption and misconduct to thrive in the Republic of South Africa following such incompetence by people employed in key critical capabilities of state to ensure the fair administrative action for everyone in the Republic of South Africa. Tomorrow it will be you. They will be telling you that we did it with a soldier, we did it with Mangolele, he was a commander in the Navy, and then you are just only a mister. Who are you to be telling us that we cannot be doing this particular thing? That is what I am fighting for. That is what I want to prove to you all people, that it is possible for one to represent themselves. It is actually an absolute right for one to represent themselves if they so choose. You can so choose to have the state representing you. You can so choose to have an attorney representing you, or an advocate be appointed by such an instructing attorney in whatever case may be. It is the reality that I am telling you. Good people, I am not a vexatious litigant. I am not a fraud that I am being made out to be by people employed to uphold the rule of law. The rule of law dictates directly to all of you that for this particular matter to have been in terms of section 21B, the reality of it, it must have been after hearing this person. A question you should be asking yourself here was that, was I heard on the 14th of September by Davis J for you to be treating me and my family like we are rubbish? Was I heard? Was I given an opportunity of being heard on the 14th of September by Davis J when this particular court order was made? Was I heard? And then you expect me to be coming and fighting with security in court and hurting the poor people and endangering their lives and their health in relation to the anger that you are instigating on me intentionally so as to protect criminal activity, corruption and misconduct? Was I heard on the 14th of September as you are claiming that I was in Cape Town? Stop ridiculing me. And stop ridiculing the laws that our mother and father has fought so hard for us to actually have in this particular regard. I ask you, Ms. Ruanne Davis, go tell Judge President Hlophe or Mangolele does not obey a manifestly illegal order. Judge President Hlophe must consult the obligations imposed in terms of section 1996 of the Constitution, read with section 2E of the Defence Act and the Code of Conduct for uniform members of the South African National Defence Force. It does not make sense for you to be forcing me to believe I was in Cape Town on 14 September 2018, whereas the reality is that I was in Pretoria, and the record of court of Pretoria can prove to you that truth. And for it to prove to you that truth, I must come to court and say, court, this is the reality. And in coming to court, it needs to be in a position where I follow the rules and procedures laid down for coming to court, which I have followed. I am not there to fight with anyone in the High Court of the Western Cape. We are not living in an apartheid Republic of South Africa. We are living in a democratic Republic of South Africa, in which public administration is in terms of Chapter 10 of the Constitution, which is the supreme law of the Republic. Law or conduct inconsistent with the Constitution is invalid. Ms. Ruanne, David, your conduct is invalid for denying me access to the court. Judge President Hlophe, your conduct is invalid for denying me access to the Western Cape High Court. You must go and arrest Samuel Hlongwane there in terms of Rule 9 that will be prayed for in the uniform of court, in the record of court. Good people, I am the defense force. I stand against corruption. I end corruption. When you are corrupt, you must get out of office and allow the people who wish to assist all South Africans to achieve equality to enter such office, and let us move forward. Do not abuse your power or authority as an upper guardian of their children's rights to deny Mangolele to be with his children, to support criminal activity, corruption and misconduct that is sustained in the DOD PESOL system since 8 August 2018 by Vice Admiral Samuel Hlongwane in collaboration with General Solishoke. A simple thing that must be done in accordance with the Constitution and the law. Lona, you are saying, no, Mangolele, uyadelela. Remove delela. Let's deal in accordance with the Constitution and the law. I am tired, I'm sick and tired in this particular regard. I have requested you in the email to act in terms of Rule 2.5 of the Uniform Rules of Court to direct whether we are going to have this particular matter heard virtually as the Chief Registrar of the High Court, and then I expect you to obey the Uniform Rules of Court and respond accordingly. Chief Registrar of the Western Cape Division of Cape Town, Mrs. Ruanne David, I ask you to obey the Constitution and the law, including the rules of court. Judge President Hlophe, I ask you to obey the Constitution. Security of the Western Cape High Court, I ask you all to obey the Constitution. It is indeed a constitutional guarantee whose source stems from the obligations imposed in terms of Section 34 that everyone, including me, has a right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. It is an obligation that is imposed, it is an obligation that must be fulfilled. Do not play games with me, Papa Ote. I thank you. In that particular regard, please allow these particular proceedings to proceed as they should proceed. I thank you.